Thank you very much again for your kind invitation. In this presentation, in my presentation, actually, I will present some aspects regarding the position of the fiscal authority in the criminal proceedings, plea agreements, and the interface of tax and criminal tax proceedings, self-disclosure, but is the perspective from the fiscal procedure code. So in the second slide, in the second presentation, in the overall context of financial control, the tax control has its own specific given by the task and the purpose it fulfills. In the Romanian tax system, a mainly declarative system, the tax authorities receive control attribution in order to ensure that all taxpayers fulfill their obligation. So you can see the model of organizing the fiscal control in Romania. It should be noted that with regard to the conduct of the tax authorities during the performance of the tax control activity, it must comply with a number of obligations, such as the obligation to objectively examine the tax situation of the taxpayer subject to the tax inspection, the obligation to take into account all the edifying circumstances for determining the tax state of affairs, the obligation to exercise the right of assessment within the limits of reasonableness and fairness. So at the next slide, Another aspect considered in this presentation is about the right to be heard. The right to be heard as an essential element of the right to defense and the right to good administration, and also as an important procedural right of the taxpayer. Observance of this right allows the clarification of the factual and legal situation, leading to the finding of the true and the possible avoidance of erroneous decision that would have the effect of formulating costly appeals. In the next slide, we have some aspects regarding the obligation to cooperate. The taxpayer or the payer is obliged to cooperate with the tax body in order to determine the tax state of affairs by presenting the facts known by him in full according to reality and by indicating the means of proof known to him, a collaboration in the administration of evidence. Unlike the old regulation, the Romanian legislator provided a limitation of this obligation, namely compliance with the provisions in criminal matters and criminal proceedings. These express limitations support the content of the presumption of innocence, the right to silence, and the non-self-incrimination. Although it is expressly provided by the criminal legislation that the right to silence does not belong exclusively to the criminal field, from the jurisprudence of the ECHR, we note that this right, it is also applicable in administrative matters, including in the field of administration of taxes, fees, contribution, when the taxpayer risks a criminal sanction. In this context, the right to silence also refers to the taxpayer's right to not make self-incriminating information available to the authorities. If the tax authority, by exercising the right to address third parties for obtaining information about the taxpayer, enters into possession of data, documents that may incriminate the taxpayer, it is not considered that any prejudice to the right to silence. In the next slide, in the content of our presentation, we approached aspects regarding the fiscal inspection report. Based on the fiscal inspection report, the tax inspection body drew up fiscal administrative acts, the taxation decisions, the decision to not or to modify the tax base. The tax inspection body has the obligation to notify the competent judicial bodies in connection with the findings included in the fiscal inspection report and which could meet constitutive elements of a crime under the conditions provided by the criminal law. And in the next slide is this situation. In this situation, the tax inspection body has the obligation to draw up a minute signed by the tax inspector and by the taxpayer, subject to the inspection, with or without explanation or objection. This minute represents an act of notification and is the basis of the notification documentation of the criminal investigation body. The provisions of Article 132 of Tax Procedure Code are thus in harmony with those of Article 61 of the Code of Criminal Procedure. The obligation to notify the criminal investigation bodies provided in the Tax Procedure Code has the same content as the one stipulated in the criminal law. The concluded report constitutes an act of notification of the criminal investigation body and cannot be subject to control through administrative litigation. Even the Constitutional Court noted that, in essence, the minutes are an official document recording certain facts or legal acts. The bodies provided by the Code of Criminal Procedure, drawing up the minutes, records in detail the facts, listing the elements on which it is based: personal findings, statements, documents, other documents. In this context, the court concluded that the activity of tax verification carried out before the beginning of the criminal investigation and materialized in a report cannot constitute a means of proof in the sense regulated by the Code of Criminal Procedure. We also specify that during the event Justice 2020, of the chief prosecutors from Romania, the issue regarding the documents drawn up by the National Agency of Fiscal Administration were debated if these fulfilled prior to the notification of the criminal investigation body may constitute evidence in the criminal process. The issue was clarified by referring to the rules established by the Code of Criminal Procedure and the decision of the Constitutional Court of Romania. But although the following issue was also discussed, whether the relation provided to NAFA by the suspect or defendant, explanatory notes, memorandums, may or may not be used against him. The undisputed solution to the content of the right to non-self-incrimination is that they cannot in any case be used against the suspect or defendant. In the slide number 9, I think, okay, so based on these minutes, the tax body organized the tax record of the amounts representing the damage entered in these minutes, distinct from the record of the tax receivable. The taxpayer, the payer, or some other interested person may pay the amount entered in the minutes or, as the case may be, the claims of the tax body entered in these documents by which a civil party was constituted in the criminal proceeding. It is considered that this record formula was established in order to ensure the necessary framework for the application of the causes of impunity and reduction of penalties provided in law number 241 from 2005 for preventing and fighting against tax evasion. We must mention that whenever by the documents issued by the judicial bodies, it results that the person who made the payment does not owe the amounts paid, they are refunded, the right to restitution being borne on the date of communication, the act by the judicial body. In slide 10, we have another aspect that we address in this paper, the clarification of the notion of the tax authority and its capacity in the criminal procedure, and also the issue, the National Agency of Fiscal Administration, acting as a civil party in the criminal trial. Those, according to the Romanian tax legislation, the Central Tax Authority is the Ministry of Finance. The tax procedural legislation introduced the definition of the fiscal body, the central fiscal body, the local fiscal body, as well as other public institutions that administer tax receivables. The Ministry of Finance also has the attribution of representing the state as a subject of rights and obligation before the courts. And the National Agency for Fiscal Administration has the power to represent the state before the courts and criminal prosecution bodies as a subject of rights and obligation regarding tax and custom legal relations. If we consider the tax evasion cases, the injured party is always the Romanian state through the Ministry of Public Finances, through the General Directorates of Public Finance, which is a civil party in the criminal process. In all cases, including where the notification is the file does not come from a unit belonging to the Ministry of Finance, the point of view of the competent financial body regarding the establishment of a civil party and the estimated damage must be expressly requested until the investigation is completed, regardless of the finding of the specialist or accountant. If the criminal case has been registered as a result of an ex officio notification, insofar as it does not hinder the investigation, the competent tax authority will be forwarded the information held in order to carry out a thorough verification and subsequently communicate whether it intends to is a civil party in the criminal proceeding. In an opinion, it is appreciated that in the issue of the legality of the Constitution as a civil part of the NEFA in the criminal process, in connection with claims arising from the commission of acts of tax evasion, the act must be taken into account to establish with certainty the existence of the damage and its extent. In this regard, we must keep in mind that this certainty of the amount of damage cannot always be respected because they are crimes of tax evasion in which the material element consists in the destruction of the financial accounting records. In this situation, the tax authority will estimate the damage and the court will decide on the existence of the damage in extent, the manner of production, and also guilt. The estimation of the damage can be made also on the basis of the judicial expertise or of the technical scientific reports drawn up in case of ex officio notification, the Romanian state being a civil party in this situation. So the documents do not constitute tax receivable titles, but represent procedural documents that can be evidence according to the law, assessing the law damage based on establishing the tax implication of evading taxes, fees, contribution, and other amounts of a fiscal nature due to the general consolidated budget. In this context, in the paper, we discuss about estimates in Romanian tax law according to the Article 106 from the Fiscal Procedure Code. The tax authority established the base and the related tax claim by reasonably estimating the tax base using any evidence and means of proof provided by law whenever it cannot determine the correct tax situation. And in the slide number 11, we discuss about the issue of the correct application, interpretation of the tax legislation by the criminal investigation bodies during the criminal investigation period. An opinion showed that the shortcomings of the criminal investigation of a tax crime on the entire circuit, prosecutor, investigation body, prosecutor, starting from the premise that these people have no training in the difficult and complex field of taxation. In analyzing this vulnerability, we must also take into account the content of the activity report of the public ministry, which indicates causes of delay in carrying out procedural acts, among which we note lack of access to National Agency of Fiscal Administration databases for the specialist of the prosecutor's office, with serious negative consequences in the investigation, with celerity, especially on the files having the object tax crimes, professional experience also, and low specialization of many police officers in economic and financial matter, imposed and continues to impose either withholding by prosecutor of the cases in his own investigation or the detailed indication of each investigation act to be carried out. Also, involvement of the judicial police workers in economic crime investigation, structures in activities other than criminal prosecution, as well as in the criminal prosecution activity or specialized structures of the public ministry. Even in this context, we must show that in accordance with the legal provisions in force within the prosecutor's office, were transferred to the anti-fraud directorate of the NAFA anti-fraud inspectors, who were thus employed as specialists according to the legislation on judicial organization, and who work in the prosecutor office. And they shall, at the request of the prosecutor, perform technical scientific findings which constitute means of proofs under the law, financial investigation in order to make goods unavailable, and any other tax audit ordered by the prosecutor. And finally, some statistical data regarding the investigation of the anti-fraud inspector in economic financial causes. And Cristian will discuss about some conclusion regarding this first part and the criminal part of our presentation. Thank you very much.
Thank you. I will take over and try to summarize, since the time limit is up and near to the narrow. I wrote some thoughts as regarding the issues we are talking about. So we have the right to be heard. Is this an effective right or just a formality? From the practice, I can say that it's just a formality. I mean, nothing changes when the fiscal inspection is finalized and the inspectors are asking for the final saying of the taxpayer. Nothing. In any case I had in my practice, nothing did change at that final moment. So they have their idea of finalizing the fiscal inspection established already. So this right to be heard is only a formality under our administrative and judicial practice. The obligation to cooperate, how long does it last? I mean, how long and which are all the elements of this obligation to cooperate? I think that the limit could or would be the right not to self-incriminate, which is an applicable right also to legal entities. About the fiscal inspection report. In our law, it is considered to have an administrative nature, and it cannot be contested. One cannot contest or formulate an action to dissolve that report in court, since we have a decision, a guiding decision from the Supreme Court saying that this act has actually no ability to be contested into the court. You can contest the decision, which is issued after finalizing the inspection and after issuing this inspection report, then you can contest it, but you cannot contest the fiscal inspection report. One consequence, which is very, very important, if the anti-fraud bodies, which are part of the Ministry of Finance, as my colleague did underline, they establish an amount as a fiscal damage, then that amount cannot be any more contested through administrative courts. You can challenge to some degree only in criminal courts through an expert report. Otherwise, that amount will remain to be included into the indictment act, and the consequence is very important, since we have provisions that can determine a more lenient criminal responsibility if the taxpayer or the defendant, in our case, would cover the damage. Just a few words about the plea bargaining. We have a plea bargaining system in Romania since 2010, but it's subject to a procedural, of course, moral procedural elements, which I have to underline only 2 or 3 of them. The limit of the penalty should be fine or no more than 15 years of the imprisonment. The plea bargaining agreement can be initiated by the prosecutor and by the defendant, but it's subject to approval by the hierarchy superior prosecutor. So the chief prosecutor has the final saying in implementing this plea bargaining agreement, but not the final word, since the plea bargaining agreement has to be approved in the end by the court. So it has to have, let's say, 3 approvals: one of the prosecutor of the case, the second one from the chief prosecutor, and the third one from the court. The court also can reject it, even if in the case that the court considers that the penalty is more lenient, is not so severe as it should have been. Also, in this case, the court can reject the plea bargaining agreement. Also, we have provisions in Law 241 from 2005, which cover the situation when the taxpayer, the defendant, covered the damage, but he or she should cover not only the damage itself, but the damage plus 20% calculation. I will close up here since the time is up. Thank you very much for your attention, and I hope that we can clarify some aspects during the question section. Thank you very much. Köszönöm szépen, vielen Dank.